Sypriss Smith. I'd like to reserve 2 minutes for rebuttal.
2 minutes. Very good.
May it please the court, the primary question before this court now for the second time in this case is whether, under the Tennessee Public Protection Act's mandatory attorney's fee provision, the trial court abuses its discretion when it reduces the successful plaintiff's mandatory attorney's fee award by 73% because the court subjectively believed that the case was simple and straightforward and over-relied on that premise. The answer is yes, that is an abuse of discretion. The Tennessee Public Protection Act mandates attorney's fees for a prevailing plaintiff. Nearly every other statute that awards attorney's fees in this state has a permissive attorney's fees provision that says that the court may award attorney's fees. That includes the Tennessee Human Rights Act, the Tennessee Disabilities Act, the Tennessee Consumer Protection Act, all say that the court may award attorney's fees. But the Tennessee Public Protection Act says shall, showing a clear preference and support of compensating attorneys who take these cases to represent these clients. The outcome at the trial, or the outcome of this matter, like so many things that this court considers, has the possibility to send shockwaves through the legal process in this state, particularly when representing, particularly for attorneys who represent employees in whistleblowing cases. The trial court's decision, now twice, has rips the teeth from the TPPA and sends the message that if you represent a low-wage whistleblowing employee, you will not get paid for your time. And it will send a message to low-wage workers that their cases are not worth a lawyer's time and effort. So again, as I say, this is the second time we're here. I know that two of your honors were here for the previous time, so I won't belabor the facts of this case other than to say that Ms. Smith was an employee of daycare. She witnessed staff abusing a young autistic child and was fired after she reported it to the government. She filed suit under the Public Protection Act and was successful at trial. The first time the court awarded attorney's fees of $12,500, which we appealed. This court vacated the trial court's order because the trial court overemphasized the proportionality of the award of the attorney's fees requested to the damages, and then also because the trial court failed to follow the guidance of Rule 1.5A of the Tennessee Rules of Professional Conduct. So we went back and filed new motions with additional affidavits and testimony, and the trial court again reduced the attorney's fees, this time to $32,000, which was 2 times the amount that the court figured the plaintiff's attorneys would have been paid had this case settled at mediation. And so,
did the court explain why it made the reference to what attorney's fees were incurred as a mediation? Why that was a big point?
Yes, Your Honor. So to give the reason that came up was because we were discussing the contingency fee factor of Rule 1.5A. And so he looked at that and he looked at what the offers were at mediation, which usually obviously is not admissible. However, there were punitive damages in this case, so that information had come in to discuss that. And so he looked at that amount, which was the final demand from the plaintiff's side at mediation was $40,000. And so he figured that the attorney's fees that Ms. Smith's attorneys would have gotten at that point was $16,000, which he doubled to $32,000 for his damage award in this case. Now this time, my brief is filled with a lot of examples of how we think the court abuses discretion. But in my discussion with you today, I'd like to focus primarily on 2 aspects of it. The first, that the trial court repeatedly relied on an improper assumption about what the jury was thinking when it issued its damages award, and used that damages award again as a gauge for issuing attorney's fees. And second, the trial court overly focused the trial court's subjective primary belief that the case was too simple to warrant the requested fees, and used that premise to interpret almost every 1.5A rule that was applicable. Remember, since we're dealing with an abuse of discretion, just remind the court that the court finds that in 3 instances primarily: when the trial court applies an incorrect legal standard, when it bases its reasoning on an erroneous assessment of the evidence, and when it employs reasoning that causes injustice. Each of those occurred at some point in some of these instances. First, the trial court, in discussions of what a reasonable fee would be, pointed out that while Ms. Smith was successful on her TPPA claim, she was not successful under Tennessee Disability Act claim, which she had brought in the alternative. The key point of that, though, is that she could not have been successful on both claims. She could have been successful on one or none, but not both, because under the Tennessee Public Protection Act, an employee must prove that the whistleblowing activity, the refusal to stay silent about illegal activities, was the sole, only cause of her termination. Under the Tennessee Disability Act claim, the plaintiff has to prove that the disability or medical condition was a motivating factor in the termination. If there is a sole cause, there cannot be a motivating cause, and if there is a motivating cause, another cause cannot be the sole cause.
Did the jury charge reflect that?
The verdict sheet, which is in the record, specifically says, did the plaintiff meet her burden to prove by preponderance of the evidence that refusing to remain silent about illegal activities was the sole cause of her termination. So that language is in the statute, which was read during the jury charge, and the jury sheet itself contained that explicit language.
Perhaps I wasn't clear in my question, but my question is, did the jury charge or did the verdict form reflect that if you find for the plaintiff on one count, that you cannot find for the plaintiff on the other count?
It did not explicitly state that, Your Honor. However, we think that the language sole cause is self-explanatory, and I think that the jury could reasonably interpret the difference between a sole cause and a motivating cause.
Was that discussed before the jury charge was submitted?
It was not there was no dispute over the language of the jury instructions or charge. And so it was not discussed.
Seems to be you're answering a different question than I asked.
Sorry, Your Honor.
Was that discussed before the jury charge was submitted?
It was not. It didn't come up as a question.
Okay.
And so but when we were discussing this difference, the trial court implied what the jury thought and said, I don't think that's the way, I don't think that the jury looked at it that way. And, and then kind of went on to talk about the damages award and why they chose a low damages award, which shows that in the court's opinion that the jury didn't think very highly of our case. And despite reading directly from the verdict form, where the sole cause standard was stated, the court ventured into the brains of the jurors to speculate how they didn't understand the words in front of them, and reduced Ms. Smith's fees award in part on that speculation. And that, we believe, is an erroneous assessment of the evidence.
Did the trial court give objective reasons for why it found your fee request unreasonable?
Objective opinions is difficult for me to say. If I don't believe.
Well, let me rephrase it then. Okay. Did the trial court give reasons why it found your fee request unreasonable?
Yes, Your Honor.
And what were those reasons?
Those reasons were primarily that he believed that this was a simple and straightforward case, that it wasn't complex. And he reiterated that while discussing several of the Rule 1.8 factors, and so, or 1.5a factors. So he believed that it didn't warrant all of the time that was put into it, although the court did not note any specific time entry that, or not even a specific time entry, but any category of activities that wasn't necessary. He acknowledged the depositions that were taken, the mediation that we went to, and as a reminder, we had a mediation scheduled. The defendants, the day before, decided they didn't want to mediate anymore, although it was court-ordered. And so we had to go back to the court and have the court reorder them to mediate. So we essentially had prepared for mediation, twice and drug the case along further. And that was the court's primary emphasis. Now, the court mentioned losing on the Tennessee Disability Act claim, which again we think is erroneous because we couldn't win on both. And then he also talked about primarily, or in large part, the belief that the jury didn't think that there were plenty of valid defenses for the defendant, that the defendant's witnesses were credible, and that the case could have gone in favor of the defendants. And somehow that bore on his opinion. I don't get the connection, but that was stated numerous times during his analysis, or the court's analysis, excuse me, for what justified reducing the fee award. In fact, there was when we were discussing the reputation and experience factor, because he did go one by one down the factors and list them. But instead of actually addressing the reputation and experience, the court said, regardless of the reputation and experience, the jury decides the damages. And again, the damages were small because I think she was making $7.25 an hour. And then the court goes on to talk about how she was late to work and there were other reasons that she could have been terminated, and says, that's the stuff that the jury should have considered. So our position, Your Honor, is that while the court mentioned these factors, the court had a predetermined opinion that the case was not as valuable, was not valuable enough to warrant the requested fees. And so that the analysis that was conducted, we don't think exactly aligns with the issues. That was one example where the court just simply deviated from the factor to say the jury didn't think the claim was valuable. Another instance was when we were discussing the time and labor required element. That's factor number 1 of Rule 1.8a. The trial court said, quote, I know there was some testimony at trial, according to the pastor, that she quit or left, and I think the jury found that was a motivating factor in discharging her, which is, again, not what the jury found. The jury found that the sole cause of termination was the call to DCS, which has not been appealed either time. That's not in
If you'll wrap up your comments.
Oh, excuse me. I'm sorry, Your Honor. I will take up the rest on rebuttal.
All right. Thank you very much. We'll hear from you again on rebuttal. Good afternoon, sir.
Good afternoon, sir. Your Honor. My name is Nathan Pride, and I have the great opportunity to represent All Nations Church of God, who owns a daycare center called Clement Child Care Center. Perhaps Attorney Martin and I were at different proceedings, but if I recall right, this is what I call a bucket of mud case. The plaintiffs took a bucket of mud, threw it at the church, and said, we're going to see what sticks. They filed a lawsuit that consisted of 3 claims initially, 3 full claims. A claim stating that the church fired this lady because she would not join the church and become a member of the church while working at the daycare center. They filed a charge against her alleging that she was disabled, and because she was disabled, the church would not allow her an opportunity to go to her doctor just about 3 or 4 blocks away and get shots on a daily basis, and consequently they fired her because of that. Then they amended their claim later on, actually 4 claims, to say we have an EEOC claim as well that we'd like the court to consider. And then finally they said that we have a claim against her because they fired her because she called the DCS and said, I saw him whoop 2 children, and because of that I didn't like it, and I'm reporting that to you all and church fired me. Well, we tried this matter. The day before trial, one of the claims was released. The EOC claim seemed to just disappear. The jury heard all the facts and circumstances, dismissed one claim, but did come back and say, you had a smoking gun on this last claim where you say she called DCS, they came out and looked at it, and as a result of that, you got fired. That reason was because the pastor called this young lady the day after, I think, the DCS came out and investigated the church and said, Ms. Smith, your service no longer needed. We appreciate that. You saw what happened today. And that was it. They had a smoking gun. Clearly, that's all. They played the tape for the jury. That was it. After the trial, the jury saw fit to award. The request by the plaintiffs was for an award of $100,000 in compensatory damages and $500,000 in damages on a punitive nature, $600,000 total. The jury award was $3,000. The jury award for punitive was $12,000 for a total of approximately $15,500. The trial judge heard the facts. He made an award of attorney's fees. He used what he thought at the time was the correct standard, which was not, and this came up to this court. So this is the second time we've been here, so I'm not going to spend a lot of time going over the facts. The court remanded it back to Judge Allen and said, give us the factors that you use so that there's not an abuse of discretion or appears that way. Judge Allen went over every factor that the court asked him to go over. This case was as simple as pie. He said to them, you only won because you played this tape that said, Ms. Smith, your services are not rendered. How complex can that be? You are citing complex legal theories. You're citing complex suppositions, constitution issues. I don't see that here. He heard the case, 2 days of trial, witness after witness after witness, entry of evidence after entry of evidence, most of which consisted of timesheets and medical records. Very little other than the tape was on the claim that was prevailed upon.
So why did the trial court find the appellant's claim for attorney's fees excessive or inappropriate?
Because, Your Honor, the plaintiffs filed an attorney's fees affidavit that consists of approximately 15 pages of invoices, over 600 entries, and approximately over 400 hours of services. How complex is it to try a case and prepare for a case where all you do is push a button? So it made sense to the court that—
You're misunderstanding my question. What did the trial court, what was its reasoning in saying that was, I know, I've read the transcript, and I know that's your language about pushing the button. That's
Yes,
not the trial court's language. So what did the trial court find?
Give me find that the motive, the main factor was?
Why the trial court said this request for over $100,000 in fees is excessive?
Because you could not, it would not be reasonable for the court to assume that over 400 hours was used just on the issue that the plaintiffs prevailed upon. Their claim, and Attorney Martin argued that this is a TPP claim. They could not show the court where they used day one for the TPP claim. They could not show where they used day two for the claim for her medical issue there, or that the third day hours were used for a claim for she was fired because she did not attend the church or would not join the church. It was just 600 hours, 600 entries, over 400 hours that was not broken down in any type of way. So the court, on its own, having nothing else to go on, assigned a value to those times and decided that this was worth approximately $32,000 in attorney's fees. If mathematically, it's a greater percentage than it would have been otherwise. And so that was the court's rationale, just not complex enough to warrant that.
Aren't there actually two questions? The first question is the fee requested appropriate? Trial court said no. Second question is, if not, then what fee is appropriate?
That would be correct, and I think Judge Allen addressed both questions. When he went down the factors, he opined that the value of the case of attorney's fees was $32,000 after it came back, and he used the motivating factor.
You're anticipating my question because, again, I've looked at this, and I think I understand what the trial court said about why the requested fee was inappropriate, but I have no idea how the trial court got to the figure it got to.
The judge did not opine to us, Your Honor, his mathematical calculation of the attorney's fees.
Isn't that why we sent this case back the first time?
In my opinion, the court sent it back because he used no factors whatsoever in determining the attorney's fees. He simply said that this case was not complex.
And how is that different than this situation? Because we know the trial court said the requested fee is inappropriate, and it told us why.
And the difference in this case, Your Honor,
We don't know how the trial court got to the number it eventually got to.
the court had no guidance, Your Honor, from the record as to how the attorney's fees were calculated. I think it would have been wrong for Judge Allen to try to go through 600 entries and say, this one is relevant, that one is relevant, hour here, hour there, hour there, hour there. The court could not do that. It just would not make any sense to the court to do that under the circumstances. So the court using the factors, weighted that and determined that the attorney's fee should be the $32,000. I could guess at it, but I would not want to do that since it's not in the record.
So you agree there's no guidance in the record how the trial court got to $32,000?
I would assert, Your Honor, there's no mathematical calculation for it, but I'm not sure the court's required to use that. I believe that the standard proof is discretion. And so the court using its discretion and using the affidavits that we submitted about local fees and determining what would be approximately reasonable, did just that. I think if you took the $250 an hour that Judge Allen used and divided that by 32,000, you come up with the exact hours. I think that was the judge's interpretation of it. And I think that would be quite reasonable under the facts and circumstances and would lend the court to affirm Judge Allen's decision. He followed the factors almost to the T. And he gave weight to those factors that needed weight. And he opined that this simply was not a complex case. And I think the burden lied upon the plaintiffs to say that of this 600 entries, 100 were associated with this particular claim, or we had 100 hours associated with this claim, but they could not do that, Your Honor. So it would cause the court to have to guess upon it. And the court used the best that it could in terms of calculating the fees. So again, Your Honor, without saying anything more, this is a case where the court did exactly what you asked it to do. It tried this case. It heard the facts. The court has great discretion. I don't think there's been an abuse of that discretion. The court, with the limited knowledge that it had on the factors given by the voluminous request for attorney's fees by the plaintiffs, who could not say this much was set aside for each one of these claims, these 4 claims they presented, the court calculated and set a fee of $32,000. We'd ask the court to affirm that fee.
Thank you, sir. We'll hear rebuttal.
On the one hand, the defendants argue that we submitted way too many attorney's fees, that there was no way to tell what was reasonable. And then on the other hand, say that there's nothing in the record to tell what, to review. That doesn't make any sense. We gave a significant amount of detailed, probably more detailed than they're even required to be, time records. The court doesn't have to comb through everything, but the defendants could have identified a single thing, a single entry, or a single category of items that weren't necessary, and that just never happened. If the trial court did find that $250 an hour was more in line with what the fees were in Jackson, didn't explicitly say that was reasonable, but found that that was about the right rate, which is a $25 an hour reduction. It's not going to reduce it from $117,000 to $32,000. The amount that the trial court did give would not have paid for the hours spent at trial, in the depositions, and the mediation. It would have exceeded $1,000 and more time was billed for those 3 things than the entire time that the trial court awarded. So they're incredibly detailed, and the trial court could have given some indication, but it did not. It also didn't identify any part of the case that was improper. It didn't say we didn't have to depose this witness. We didn't have to depose this witness. There weren't experts, so there's no discretionary cost for expert fees. There's no discretionary cost for expert depositions or anything like that.
Earlier, we discussed the trial court making a reference to what the fees would have been at the close of the mediation. But is there a document that tells us what the fees were at the close of mediation?
No, Your Honor, and the fees almost certainly exceeded that at the mediation. I don't know what they were. That, he knows what the settlement value was because of what the testimony was, so that we'd offered to settle for $40,000, and that was the estimation that the trial court made. And so, and then there's one more thing that the plaintiff likes to talk about, how this is a simple, or the defendant, excuse me, simple case, push a button. And because they had a smoking gun. Well, if that were the case, it shouldn't have gone to trial, and it should have been resolved way sooner. But it wasn't. There, in a TPPA case, excuse me, where we have to show sole cause of termination, which we have 3 attorney affidavits saying that that's a very, very difficult burden that they turn cases away for. We don't just have to prove our case. We essentially have to disprove their case, and we essentially have to say all their reasons are baloney. And so that does require more depositions and more time, and it's more work. We don't have a crystal ball. We don't know what the jury's going to do, and we can't bill less simply because we can't work less simply because our client is a low-wage earner. If Ms. Smith had been an executive and made $150,000 a year, and she got a year's pay as a jury verdict, then it's very likely, I think, that the court found that $100,000 in attorney's fees is reasonable. But because she made $14,500 a year, it's not reasonable. I am out of time, but I'll answer any questions, or I thank you very much for your time.
Hearing none, thank you. Thank you both for your argument.
Thank you, Your Honor.
Call the next case, please.
In Ray Houston D.